All right, now the IRCTC, the Indian Railway Catering and Tourism Corporation, they are planning big. They want to leverage their data assets. They want to do this and increase their revenue and improve the customer experience in doing so. That strategy is in place to monetize their user base as well as their passenger travel related transactions. What exactly are they planning? Let's find out. My colleague Avan is here and she's walking us through the details that we have so far as IRCTC's plans are concerned. Avan.
IRCTC in the spotlight. Incidentally, it is one of the largest e-commerce websites in India as well as in Asia Pacific, and the company is going ahead and capitalizing on this by getting into the process of really monetizing their digital assets. They're going to monetize their overall user base as well as passenger travel related transactions. So essentially they're looking at revenue potential from these digital assets. They plan to monetize things like advertising, marketing, cross-selling, promotional mailers as well as SMSs, and this is through the website as well as the mobile app. The company already has been monetizing their digital assets and gets revenue from ads, image capture, Ask Disha chat, Facebook, jingle campaigns, etc. And now expressions of interest for a presentation on monetization of their digital assets has been invited. And just to put some numbers into perspective for IRCTC, they have a registered user base of close to 6.64 crores already. The online booking as of 2018-19, as per the numbers have given, has been 70% of the total reserved tickets. The highest tickets in a minute has been something like 20,610. The average daily logins for mobile app in 2018-19 has been about 35.2 lakhs. The average daily mobile app downloads has been 37,000 odd, and the average ticket bookings per day for 18-19 has been close to 7.78 lakhs. So a lot of potential from digitizing their overall assets, from monetizing their digital assets rather for IRCTC.
That's right, Avan. IRCTC planning to leverage their data assets. They want to increase their revenue. They want to improve their customer experience. We'll see how much of that is accomplished in times to come. But it raises several questions when it comes to data protection, data safety, data privacy. Let's discuss this with N.S Nappinai. He's an advocate at the Supreme Court and the founder of Cyber Saathi. He's joining us on the show tonight, along with Prateek Waghre, who's Policy Director at Internet Freedom Foundation. Thank you, gentlemen, for making the time on speaking on this subject. Mr. Nappinai, to you first. At a time that India really lacks sound legislation for data protection, and this was 5 years in the making, the Data Protection Bill of 2019. It was designed to protect the privacy of Indians. It was withdrawn by the government recently. In that kind of scenario, you have the Indian Railway Catering and Tourism Corporation floating this tender to hire a consultant to monetize their digital assets. That's the news. But there's no taking away from the fact that any enterprise requires capital to grow. How do you raise capital is the real moot question. They want to monetize their digital assets, basically the database they hold of you, me, a whole lot of Indian citizens. Is that a fair proposition according to you?
Now, here's the problem, Vikram. IRCTC was and continues to be one of the biggest e-commerce sites. So when we talk about train reservations, irrespective of whether it's a public sector organization or not, you're providing a commercial activity. So when you're talking about data protection, and this is where it gets into the murkier domain. One, as long as you're considered a body corporate, then you're amenable even to the minimalist laws which are already there. So it is very wrong to assume we don't have data protection laws. Today, we do indeed have under the Information Technology Act. The larger issue is the proposed law, which was supposed to come in, and it was in fact 1 year before the 2019 draft also. From 2018, we have been seeing multiple drafts, and the withdrawal of the 2019 draft was supposed to pave the way for a new law to be reintroduced. But that has still not happened. Only one part of the process of withdrawing the earlier draft to pave the way for the new draft to come in has happened, but we really need certainty in terms of when and how the new draft will come. So when you're talking about the kind of data that IRCTC captures and what is permissible for it to then share, consent will become almost like a Hobson's choice, because you don't have a choice but to share a lot of personal data when you are buying train tickets. So you have partially a governance aspect where government is technically collecting the data, and government would be amenable to the law if the new Data Protection Act had come into play. And we are still waiting for it. Whereas under the old act, if you look at it as a commercial activity at a body corporate, then you can claim protection. It may not really fall within that domain. And this is where users are caught in a difficult position. 90% of Indians still travel by train.
Yes.
And it is a necessity for them, and it is not a luxury. It is not something where they can take this choice of take it or leave it.
That's right. The
they
choice
don't
is
have
not
a choice
for the
often.
consumers to make.
And you're
in
then
this case
asking them to share data,
yes,
and then telling them we will use it however we want. That is not really acceptable.
Right.
One more reason why we need a new law, and which has to ring fence what is permissible and what is not, in terms of not just collection of data, but also how
But ma'am, this is going to take a while to come. Until then, what happens? Prateek, Waghre, do come in. The digital assets that we're talking about over here, as mentioned in that tender, they include rail ticketing data. They include the user base and passenger travel-related transactions. Sometimes, like the cliche goes, the ends justify the means. Now, IRCTC is saying they want to monetize their data to increase their revenue and to improve the customer experience. Would you buy that argument, or would you say there are other ways to raise your revenue and one should not compromise data privacy at all, because it's not the reason why customers shared their data with the IRCTC in the first place?
Yeah, look, no, that's an interesting question, right? And if you look at, so this goes back to, I think, a deeper issue with how we tend to view data as a sovereign wealth resource, right? Rather than something else. So which creates then incentives for you to try and accumulate this data and then monetize large volumes of data, right? Now, should the government be in the business of trying to monetize data, right? Now, between the government and between, let's say, a profit-seeking, corporation, there's on that is different, right? So, is the government's main job really to seek to maximize profit, or is it to provide a service to citizens, right? And I would argue that yes, you can say that IRCTC is a publicly listed corporation, but as it's pointed out, it's a government. It's essentially a government-controlled monopoly. There's no other option for people who want to book train tickets, right? And it is a service that's provided by the government. So should profit-seeking be their primary incentive? I don't think so.
Well, we are talking about public sector banks earlier when it came to a bulletin that the RBI has put out as well, and they're talking about not just consolidation but privatization of public sector banks. And over there, the big debate is about whether you are going to go the private sector route, because they're talking about privatization and profit is at the heart of it rather than financial inclusion. So there is going to be that kind of dichotomy when you talk about what a public sector unit should do and what a private entity does. But when it comes to privacy of data, there is going to be some kind of uniformity. Now, that uniformity can only come through a law that binds all, that kind of ring fencing like Nappinai is talking about. Nappinai, back in 2019, there was a similar expression of interest and EOI that was put out by the IRCTC. Clearly, that did not go through. Now, the company is again attempting this preliminary exploration of the scope of digital asset monetization. They're trying to hire a consultant for it too, perhaps to make that process smoother. What, in your opinion, did not work for them back then? Can it work for them now? What has changed in the interim period, do you think? I ask you this in particular because recently the Indian government has withdrawn that data protection and privacy bill, first introduced in 2019, and had alarmed big technology companies like Facebook, like Google, announcing it was working on a new comprehensive law. That's what the government is saying. Now, we don't have that law right now. That would govern data privacy laws. How can this be legally challenged then?
The difficulty is from then to now, there is really no change. Only if we get a new data protection law will there really be a difference or a change in terms of the parent act or a parliament enacted act. So therefore, the necessity and urgency for the new data protection law is just highlighted with issues like this in terms of what is IRCTC permitted to do and what it is not. If it wants to monetize, if it is able to justify it in terms of showing how it is for the benefit of people, and we have to understand we can't put data in the same bucket. For instance, if they are talking about non-personal data, which is anonymized and which is intended to analyze and to provide better services for travelers, it's a fair point. But if it comes to personal data, and if it is data that is being collected as part of a governance mechanism rather than as a commercial activity, government has to understand that they have to delineate the two, and that which they are collecting as part of a governance mechanism cannot be shared and cannot be looked at from the perspective of profit. Vikram, you'll recollect this issue that happened with the government selling data, which it collected for part of, issuing driving license and registration numbers.
Yes.
That was purely a governance mechanism. It's not like you have the choice to go and take a driving license from somebody else, right?
Sure.
You have to do it through the government processes. How can the government on one hand give you no choice in terms of how you collect a particular process and then use your data and sell it, claiming that making a profit is for the benefit of a government agency? It cannot be done. So that fine distinction in terms of what it can do and cannot be done is something they have to draw the line on even today. The difficulty in law is law will only protect you when you have a remedy. On one hand, you have the Puttaswamy judgment, which clearly lays down what your privacy rights are. But on the other, we are still waiting from 2017 till date for an effective data protection law, which puts the government also in the dock in terms of where and how and when it will protect individuals' data. And that's why there is an urgency today for us to get the new law. The government has gone ahead and withdrawn. It has not yet given us the assurance and, more importantly, the timeline by when they intend to bring in the new draft, which is supposed to be in consonance with the JPC report.
Right.
That has still not happened. I think it's now time for the government to immediately give us that assurance that the data protection law will come in and by when will it come in.
Prateek,
and
Waghre,
to also disclose the contours to show that government will be held accountable.
Prateek, Waghre, talking about what IRCTC is doing over here, by way of a company, it's a listed entity. It trades on the bourses. As far as its performance as a company is concerned, it does stand accountable to its shareholders too. When you look at their revenues, they're talking about their margins perhaps. Their margins have been falling gradually. You see their internet ticketing, those have taken a bit of a hit in recent times. And perhaps that is what is spurring this move to hike their revenues by putting out data in the marketplace. I'm asking you, what are the global precedents for a situation like this? How strong does the privacy ecosystem really need to be to keep this within the scope of set legal parameters on data safety and data security? What is already out there that India is not doing yet?
Look, I think, in many jurisdictions around the world, they are still figuring out, how to deal with data commons and that approach, how to approach these kind of questions, right? But I just want to go back to your point about it being a publicly listed corporation. And while I get that, my point is the more fundamental one of, look, what is the role of the state in a society, right? Is it enforcing the social contract, or is it making profit? Now, yes, along the way, we happen to make IRCTC a profit, publicly listed corporation. That's a different thing, and I can't really go back and change that, and it may or may not have its own merits, right? But coming back globally, what's happening is that whether you're talking about EU, etc., they're all figuring out how to deal with data as a common entity or as a resource, right? And we've been calling it a public good, right? If you go back to the 2018-2019 economic survey, chapter 4 very famously called it a public good. Now, a public good is supposed to be non-excludable and non-rivalrous, right? But then at the same time, we're trying to treat it as a commodity, right? And that just, to me, it doesn't add up. And this is why, from a civil society perspective, this is extremely concerning. Especially as Nappinai pointed out, it comes right after the withdrawal of the data protection bill, which means there is currently a limitation in the amount of protection you have against misuse of this data, or what happens if this data is breached. Because again, it's in the EU, it's in the expression of interest state. We don't know what final form it will take, what types of data will be shared. As currently, as per initial reading of the document, it's not clear that there's any separation of what is personal data, what is non-personal data. Right. So whether there is any consideration given to the idea of anonymization, what safeguards are there to protect against de-anonymization. None of that is clear from the expression of interest. So we don't really know where that's going to land at this stage. But overall, it still remains concerning that this is happening at this stage right now, where we've gone back a couple of years, in the whole where is India with the data protection law conversation.
So every part of this is coming back to the necessity of a law that is all-encompassing when it comes to data privacy, protection and safety, something that we don't have, and we don't have a clue as to when it's going to come about. The government will have to accelerate the process that they already started and withdrew from. Until we have clarity on that, the choice is clearly not with the consumers, especially with government bodies like the IRCTC, which wants to put out consumer data out in the domain of revenue generation, and that seems to be problematic, like both Nappinai and Mr. Waghre are telling us. Thank you very much for your opinion on this, and we, of course, will keep tracking it and continue having these debates.